Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients in the area of criminal defense with a focus on Pennsylvania and New Jersey law. It is my sincere hope that this podcast will help you and your family make better decisions and help you understand your rights under the Constitution. Our law firm is committed to providing the highest level of professional service to its clients and their families. We strive to not only provide aggressive advocacy, but serve as a trusted advisor to individuals during a difficult time in their life. To learn more about our law firm, read my weekly blog, watch my instructional videos, or download a copy of my free strategy books, visit gambonelaw.com or call 215-755-9000, 24 hours a day, 7 days a week. To the Gambone Law Podcast, this is episode 4. My name is Alfonso Gambone. And every week in this podcast, as you all know by now, we discuss a different area of criminal defense. This week, I will be discussing handguns and firearms in Pennsylvania. So like always, we'll be taking a bunch of questions from our clients and their families in this area. So the first question this week is, what is the difference between a gun charge under Title 18, Section 6105, and one under Title 6106? I'm sorry, Section 6106. Well, these are very common firearms charges that we deal with in Pennsylvania. Section 6105 is possession of a firearm by a prohibited person, while 6106 is the illegal possession of a firearm because you don't have a permit, just possession of a firearm without a permit, in other words. Under 6105, which is actually the more serious charge, a person is not able to possess a firearm because of some prior conviction, also known as an enumerated offense. There's a list of offenses in Pennsylvania which prohibit a person from being able to ever possess a firearm. So under this section, which is graded as a felony of the second degree in Pennsylvania, a person is not permitted to ever carry a firearm either in their home or place of business or anywhere. Typically, these enumerated offenses are violent felonies such as aggravated assault, robbery, burglary, manslaughter, obviously murder. Also, it's important to understand that these offenses also include possession with intent to deliver a controlled substance or drug. In addition, they also include cases where a person has been convicted of a DUI 3 times within a 5-year period, and also persons who are subject to PFAs or protection from abuse orders. It's important to understand that in those situations, the drunk driving and the PFA situation, if you are charged with 6105, it's graded as a misdemeanor. In the situations where you are a prohibited person because you have a prior conviction because of a felony offense like a robbery or a felony possession case, that will be graded as a felony of the second degree. It's important to understand that in Pennsylvania, a felony of the second degree or any felony offense typically carries with it almost like a presumption of state incarceration or a serious county jail sentence. Now, Pennsylvania, it's important to understand that unlike New Jersey, there is no mandatory minimum sentencing in Pennsylvania. In New Jersey, where our law firm also practices, there's something known as the Graves Act, where many of their firearms offenses do carry with them mandatory minimum sentencing. Now, getting back to the question, 6105 is the prohibited person offense. 6106 is the possession of a firearm without a license. So in Pennsylvania, you don't need a license or a permit to possess a weapon if it's in your home or place of business. You do need a license to carry it outside of that home or place of business, otherwise known as a concealed carry permit. So in Pennsylvania, if it's in your house or in your place of business, you can have it and don't need any special license or permit. Outside of that, you need to go through the process of getting a concealed carry permit. If you don't have that and you're stopped, you will be charged with 6106 and not 6105. But if you're also a prohibited person, in the example I just gave, because you have a conviction and you're not able to possess a firearm, the prosecution will charge you with the 6105 offense and the 6106 offense. In addition, 6106 is typically graded as a felony offense, but it can be graded as a misdemeanor offense. Typically, it's graded as a felony offense because when the person's arrested under 6106, there's some other offense associated with it. Very commonly in Philadelphia, if you are charged with 6106, you will also be charged with 6108, which is a misdemeanor offense, but it's possession of a firearm on the city or public streets of Philadelphia. And that is a misdemeanor offense, a misdemeanor of the first degree, but it elevates the 6106 to a felony of the third degree as a misdemeanor, as opposed to a misdemeanor of the first degree. So keep that all in mind. It's also important to understand that a gun offense, like a drug offense, the Commonwealth or the prosecution has to establish beyond a reasonable doubt either actual or constructive possession. I've discussed this topic of actual and constructive possession in my previous podcast, as well as in all of my strategy books, and as well as in my videos and my weekly blog, all of which are available on my website, gambonelaw.com. It's a very common topic that we discuss with clients and their families. So I won't discuss it right now, but just know that if you're charged with a gun offense, your criminal defense lawyer cannot overlook actual and constructive possession. All right, next question. Can the police stop my car and search for a gun without a warrant? Well, as I've discussed before, warrantless searches in Pennsylvania are permissible. They are allowed. But police need probable cause to believe that the vehicle contains contraband. So using this gun example, it may be more difficult for the police to establish probable cause because unlike drugs, there's typically not a smell associated with a gun, and typically the driver doesn't necessarily give off the appearance that a gun is in the car. So they need something else. So for instance, if the person's just nervous or acting awkward, it's arguable whether that's probable cause. I would argue that it's not. It's at best reasonable suspicion, which is a lower form of probable cause. Other prosecutors may feel differently, but I don't think it's enough to search a car. But that being said, police can use other things during their observation. They can look at the car itself, any type of containers in the car. If it looks like it may have a gun in it, for instance, a bulge sticking out of a bag, which looks like a gun. The officer is permitted to use their training, their experience, and their knowledge to determine whether or not they believe that a gun is within the car, thus establishing probable cause to search without a warrant. Obviously, if you're stopped for a traffic stop, that in and of itself isn't enough to search for a gun. But during the police's investigation and that questioning of you as to why they stopped you, if during that detention period, if something comes up, they can obviously use all those factors to assess whether or not they believe the car has that gun in it. So really, off the top, I would say that just the stop itself would not give them probable cause. But moving on, that's why it's so important to not answer any questions from the officer except giving them the very basic information, your license, your registration, your insurance card. You are not obligated to answer any questions with regards to where you're coming from, where you're going. All that could lead to a further detention with the officer, and more likely that the officer may want to search the car at some point based on those questions. And again, it's arguable. If you are stopped and arrested with a gun charge, your attorney must consider a motion to suppress evidence, especially if the gun is found either on your person or in your area of immediate control within the car, and that in and of itself could lead to a conviction because obviously the prosecution could establish possession at that point. So you want to look at a motion to suppress and have your attorney look at whether or not they had probable cause and or reasonable suspicion to even initiate an investigation or even a search. So all these are important factors which you must discuss with your attorney. Frequently in these cases, in firearms cases, a pretrial motion like a motion to suppress is your strongest tool from a defense standpoint. All right. Let's take another question. I have a permit to carry in Pennsylvania while other states honor it. I do a lot of business in New Jersey and like to carry my handgun there for personal protection. Well, New Jersey and Pennsylvania, as I'm sure you are aware, are bordering states, but have very different gun and firearms laws. Like I said before, New Jersey, for instance, has mandatory minimum sentencing under its Graves Act for most of its firearms offenses, unlike Pennsylvania, where there's no mandatory minimum sentencing for most firearms offenses. So that being said, it's important to understand that New Jersey does not honor Pennsylvania gun permits. New Jersey actually doesn't honor any state gun permits, and it's very, very difficult to obtain a permit to carry or a concealed carry permit in New Jersey. Some say it's almost impossible. It's a very limited number of individuals who can obtain a permit to carry. Typically, it's former law enforcement or persons who have a need to carry it because of some position that they have or have demonstrated to a court that there's some issue that causes them to have a concern for their safety. And even then, it's arguable whether or not a court will actually grant it. And the permit is only good for a limited number of time, a limited period. I think it's actually like 2 years. But just understand that your Pennsylvania permit will not work in New Jersey. If you carry a Pennsylvania gun into New Jersey, it's illegal possession, and you are subject to that mandatory minimum sentencing. Now, understand that there are things from a defense standpoint that we can do to mitigate that mandatory minimum sentence. In New Jersey, under the Graves Act, there are partial and full Graves Act waiver motions that we can make, but typically those all require either the support of the prosecutor or a demonstration to the court as to why you should be granted either a partial or a full Graves Act waiver. A partial Graves Act waiver would bring down the 42-month mandatory minimum sentencing to 1 year period of parole and eligibility, while a full Graves Act waiver would translate into probation, or otherwise known as a non-custodial sentence. But it still very likely would be a conviction unless you're eligible for pretrial intervention. I'm getting off topic here a little bit, but just understand that Pennsylvania doesn't have reciprocity with a lot of its bordering states, with exception to West Virginia. So New York, Delaware, New Jersey, and Maryland, we don't have reciprocity with those states. So if you travel to those states, don't travel into them with your Pennsylvania gun. If you're simply traveling into Pennsylvania or back from a trip, perhaps you were using the gun at some firing range out of state or some competition or to have it repaired, you have to travel with the gun in a certain manner. It's very important that the gun and the ammunition are kept separately. I advise keeping the gun in a gun box or a secure container of some sort. Don't just keep it in your bag. Even if it's unloaded, just keep the gun in a separate gun box if you're traveling with it. So then there's no question as to your intention with it. You have to understand that if you don't have a permit to carry, you're only permitted to take it outside the home for to have it repaired, to a gun range, and things of that nature. You're not permitted just to drive around with it. That's, again, you would be charged under 6106, possession of a firearm without a permit. Okay, next question. I purchased a gun for personal protection in Pennsylvania. I plan on keeping it in my house. Do I need a permit in Pennsylvania? Well, no. Pennsylvania, unlike a state like New Jersey, doesn't require a permit to own a handgun. New Jersey, however, does. So in Pennsylvania, you can buy a firearm or a handgun or anything really sold in a local gun store without doing without needing a license to actually own it. New Jersey is different. The difference is that you have to understand that owning a firearm, keeping it at home or your place of business it's very different than traveling outside the home. So the law doesn't require you to have a permit to own it and keep it at your house or your place of business, but it does require a concealed carry permit to travel outside of it. Okay, I think we have time for one more question. Okay. Final question is a topic that I've already discussed, but I'll read it anyway. Can you explain the difference between actual and constructive possession of a firearm? We've dealt with this topic before. Actual possession is where it's found in your person, like in your jacket or in your pocket. Constructive possession is found in your area of immediate control. So using a car example, is found underneath the seat would be a form of constructive possession, or even in the trunk. It's arguable whether or not it's actual. I'm sorry, that's a bad term. It's arguable whether you constructively possessed that weapon. I was going to say it's actually whether or not it's actually constructive possession. I didn't want to confuse actual and constructive possession, but you have to understand something, that if you're stopped and the gun is in the car, your attorney has to look at every factor to determine whether or not the prosecution can actually establish that constructive aspect of its case. Moving on from a different example, if, for instance, police come to your home and find a gun within it, you could still be charged with a gun offense because, for instance, you are a prohibited person. So that's another area where constructive possession could be an issue. So you share a home with people, a gun is found in the kitchen area, a common area, but you have roommates. And while you are perhaps a convicted felon, not able to possess a firearm, your roommate is not. Now, the gun perhaps could be, it could be a very simple situation where the gun is registered to your roommate and there's not an issue there. But obviously, in this situation, perhaps we have one where police find a gun following a search for whatever reason, assuming that they have a search warrant. You have to understand that in that situation, if a gun is found in a common area, it's up to your criminal defense lawyer to look at all the factors which could separate you from that firearm. So with that example, if a gun is found in a kitchen and there's other people living in the house, that's one of the first issues that I would argue to a court or to a prosecutor, that there was other people there and that you can't establish beyond a reasonable doubt that you being my client, actually possessed that gun because other people were in the home, and it's very arguable as to whether or not those people were the actual possessors of that gun as opposed to you. So these are all important issues that your attorney should discuss with you. Again, I discuss all these issues very frequently in my blogs, in my newsletters, and my videos. Gun offenses typically, as I stated before, are felony offenses in Pennsylvania and New Jersey. They're either felonies of the second or third degree. New Jersey classifies most of its gun offenses and any legal firearm offenses as crimes of the second degree, otherwise known as felony offenses. There's a presumption in New Jersey, like in Pennsylvania, that firearm offenses carries with them a presumption of state incarceration. So these are very serious charges. I encourage you to learn as much as possible about them. If you are charged, I am more than happy to discuss it with you in the office. For more information, please visit our website, gambonelaw.com. That's all the questions we have this week. I look forward to seeing you soon. So one last thing before we leave this week. If you have a question about criminal defense, any area of criminal defense, whether it be a gun charge, a drug charge, a DUI, a violent felony offense, please submit your question to me. You may email me at Alfonso, ALFONSO, @gambonelaw.com. You can also visit our website and submit a question there. I'm more than happy to take the questions. I take questions every week in a different area. Maybe I'll answer your question next week.